of the appeals that have been questioned here today. Standing before court is not decided by majority rule. It is decided by injury. When I have a member of an org that is at risk of being displaced from their business or their home as a result of irresponsible development that is inconsistent with the comprehensive plan, that is an injury. If you are injured and a law has been broken by the governing administrative body, you should have remedy before the courts. This paradigm is not a filibuster. It is known as the third branch of our government or the judiciary. I'm flummoxed by the position of some council members, especially as it relates to this confusion regarding clarity in the amendments. You all write and propose laws. Is it common practice to make those laws intentionally vague? Under what circumstances might you do that? Probably when you don't want those laws enforced, no? In any event, how can we endeavor to create a so-called inclusive city when the most mulled over question before council today is how can we use the comp plan to exclude the most impacted and vulnerable from the process so the masses of those easily pleased by any kind of development may have their way? Yes, there is some friction between protecting the only injured member of a community and advancing the wishes of an entire community. Fortunately, McMillan had thousands of members, Berry Farm has scores of members, and no appeal have I brought that includes just one person and outsiders. Unlike the developers' proponents at McMillan, we don't have to hire $80,000 consultants to gather membership. In fact, our members are likely to need babysitters, work odd hours, and don't have time, nor are they privileged to effectively influence marathon community outreach efforts. You heard from Trammell Crow that the point of the appeal at McMillan was to delay. McMillan was overturned partly for statutory reasons that have nothing to do with the comprehensive plan. DHCD, among other agencies, must submit written reports to the Zoning Commission. This is to illuminate the impacts of proposed land use changes. This is never done. The adverse impact to the environment was not considered there either. If there is no will by the Zoning Commission to follow their statutory duties, projects will be delayed whether you accept these amendments or not. The solution is not to give more leeway as zoning's shown a propensity to flout laws. All you accomplish by doing that is to create a starting point for injustice that is even more injurious for residents. If you want to stop the appeals, do it with a robust administrative record and well-reasoned decisions. Courts already grant agencies deference. That this process currently fails speaks to the commission's service to the mayor and developers, not to the comp plan service to the people. As a land use attorney, I've filed 14 zoning appeals. I sleep fine at night knowing my actions have protected affordable housing. It's knee-slapping, funny attorneys from Goldstein and Stores now rep that flag.
Mr. Teresa, you
yes.
Expired. Thank you. Okay. Mr. Teresa, how many cases have you been in? How many appeals have you been involved with? Microphone.
I filed 14 appeals in the past 4 years, 3 or 4 years.
McMillan was one of them, I think you said?
McMillan was one.
901 Monroe?
No.
So of the 14, how many have you won?
One of them is pending. Well, several of them are pending. McMillan, we won. One of them's been pending. Berry Farm's been pending for almost 2 years. We fully briefed that or argued that. One of them was dismissed for standing issues, but that's only because the Zoning Commission had not been considering issues that were in the comprehensive plan. And once the court said that they had to consider them, no one knew how the court would interpret standing as it related to that provision of the comprehensive plan. And so that case was thrown out because they took a conservative approach to standing. But we've had one case won, one case dismissed, several cases have settled, and one case, well, several are pending, yeah.
And of the settlements, are there non-disclosure agreements with all those settlements?
I can discuss one settlement with you. We received $150,000 for that settlement.
And how many others were settled?
I don't think I'm at liberty to discuss that with you.
You could say they were settled or not, and I'm not asking you specific cases. I said how many.
I don't feel comfortable talking to you about how many of those cases settled.
Why?
Because I'm an officer of the court.
Okay. So,
And I have responsibilities to my clients. Contracts have been signed.
so there's a contract with a non-disclosure agreement.
Yeah.
Okay. So the one that you can discuss, what happened to the $150,000?
That goes to a community organization, and they use it how they see fit. One of those members was displaced from their business. They were an artist at 411 New York Avenue. Another member lives in a home with her uncle that she's about to inherit. Her uncle's sick, terminally ill, and she cares for him, doesn't have a job. She's sick herself. These are people who are the most impacted by development projects. They may not have a majority, they're the most impacted. And they also have the will to fight for their rights before the court, before the zoning commission. And not many people have that. And so when we are able to get something for them, they're able to use that however they want to use that.
What's the public policy behind having a non-disclosure agreement?
I don't know if there is a public policy. If you want to discuss public policy, you probably should discuss that with the zoning commission. I'm an attorney, I represent my clients. It's a very personal endeavor. If you want to discuss public policy, probably want to discuss that with Eric Shaw, zoning commission.
Well, no, I was asking about public policy regarding non-disclosure. Some would say that that non-disclosure agreements are contrary to public policy. Let me shift question.